Let's talk about custody agreements. Devin Slovensky, Virginia divorce attorney. For many parents, custody arrangements are not static forever. As children grow, schedules change, careers shift, and family dynamics evolve, what worked a few years ago may no longer make sense today. In Virginia, custody agreements can sometimes be modified, but only under certain circumstances. One of the biggest things that parents need to understand is that changing custody is not as simple as asking the court for a different arrangement because you're not happy with it right now. Virginia courts are going to require two things before modifying an existing custody order. First, there must be a material change in circumstances since the last court order was entered. And second, the requested change must be in the best interests of the child. A material change in circumstance can take many forms. It could involve a parent relocating, changes in a child's educational or medical needs, concerns about stability, changes in work schedule, issues involving communication or co-parenting, or situations where the current arrangement is just no longer working for the family. Sometimes the changes are gradual, other times they appear suddenly. The court is not focused on whether one parent wins or loses custody. The focus is on the child's well-being and whether modifying the arrangement is going to better support the child. Virginia courts look at several factors when modifying custody orders. That can include the child's age and needs, the relationship between each child and the parent, each parent's ability to support the child emotionally and physically, and the willingness of each parent to cooperate in the overall stability of the home environment. It's also important to understand that informal arrangements between parents may not be legally enforceable unless they're properly entered through the court. Even if parents have adjusted schedules on their own for months or years, the official court order still controls unless it's been formally modified. Another common misconception is that children can just simply decide where they want to live when they reach a certain age. In Virginia, a child's preference may sometimes be considered depending on maturity and circumstances, but there is no automatic age where a child gets to make the final decision. Because custody modifications can directly impact parenting time, school schedules, communication, and long-term family relationships, these cases are often emotional for everyone involved. At Slovensky Law, we help parents throughout Virginia understand when custody modifications may be possible and how to best approach these situations thoughtfully and strategically, while keeping the child's best interest at the heart of the conversation.